Article 100 of the Indian Constitution addresses the disqualification of a member of Parliament or a member of a State Legislative Assembly. Disqualification on the ground of defection states that a member of Parliament or a State Legislative Assembly may be disqualified if they voluntarily give up their membership of the political party they belong to at the time of their election. They may also be disqualified if they vote or abstain from voting in the House contrary to the direction of their political party without the prior permission of the party. However, there are exceptions. A member is not disqualified if they were not allotted a symbol by their political party. They are also not disqualified if they are expelled from their political party. Furthermore, they are not disqualified if they merge their political party with another party. Finally, a member is not disqualified if they change their political party as a result of a split in their original party. The procedure for disqualification begins with a petition for disqualification that can be filed by the Speaker of the House or any member of the House. The petition is then referred to the Committee on Privileges, which investigates the allegations. If the committee finds that the member has incurred disqualification, it makes a recommendation to the House. The House can then pass a resolution disqualifying the member. The consequences of disqualification are significant. A disqualified member loses their seat in Parliament or the State Legislative Assembly. They are also barred from contesting elections for a period of 6 years. The interpretation of Article 100 is that it is intended to prevent political instability and defections that can undermine the democratic process. It ensures that elected representatives remain loyal to the political parties that they were elected under. Firstly, the 10th schedule of the Indian Constitution was added in 1985 to further elaborate on the provisions of Article 100. Secondly, the anti-defection law has been amended several times to strengthen its provisions and prevent loopholes. Thirdly, recent amendments have introduced the concept of deemed defection, where a member is considered to have defected even if they do not formally leave their political party. To elaborate further, consider the implications of a member voluntarily giving up their party membership. This provision aims to prevent members from switching parties for personal gain or political opportunism, thereby undermining the mandate given to the original party by the voters. The requirement for prior permission from the party for voting or abstaining on key issues is also crucial. It reinforces party discipline and ensures that members adhere to the party's stated policies and positions. This prevents individual members from deviating from the party line and potentially disrupting the legislative agenda. However, the exceptions to disqualification are equally important. The exception for members who were not allotted a symbol by their party recognizes that there may be situations where a party's internal processes are flawed or unfair, and a member should not be penalized for such circumstances. Similarly, the exception for members who are expelled from their party acknowledges that a party may choose to remove a member for various reasons, and such expulsion should not automatically trigger disqualification. The provisions regarding mergers and splits in political parties are designed to address situations where the political landscape is evolving. If a party merges with another, or if a significant faction breaks away from the original party, the members' affiliations and loyalties may understandably shift. In such cases, disqualification would be inappropriate. The procedure for disqualification involves a careful review of the allegations by the Committee on Privileges. This ensures that the process is fair and that members are given an opportunity to present their case. The committee's recommendation to the House is a crucial step, as it provides the basis for the House's decision on whether to disqualify a member. The consequences of disqualification are severe, reflecting the seriousness of the offence. The loss of a seat in Parliament or the State Legislative Assembly is a significant penalty, and the 6-year ban from contesting elections further underscores the importance of upholding the principles of party loyalty and political stability. The anti-defection law, as embodied in Article 100 and the 10th Schedule, is a complex and evolving area of Indian constitutional law. It seeks to balance the need for political stability with the rights of individual members to exercise their freedom of conscience and expression. The amendments to the law reflect ongoing efforts to refine its provisions and address loopholes that may be exploited. The concept of deemed defection is a particularly noteworthy development. It recognizes that members may engage in activities that are tantamount to defection, even if they do not formally leave their party. This provision aims to prevent members from circumventing the law through indirect means. In summary, Article 100 of the Indian Constitution is a cornerstone of Indian parliamentary democracy. It plays a vital role in maintaining political stability and ensuring that elected representatives remain accountable to the political parties that they represent. The disqualification process involves several steps. Firstly, there is the filing of a petition. Secondly, there is an investigation by the Committee on Privileges. Thirdly, there is a recommendation to the House. Fourthly, there is a resolution by the House. The consequences for disqualification involve a loss of seat and a ban from contesting elections. The goal is to make sure there is party loyalty. Political stability is one of the main points of the Constitution, in that it prevents disruptions and ensures the government runs smoothly. The original intent of the framers of the Indian Constitution was to foster a system of governance rooted in principles of integrity and accountability. Defections of elected members from one party to another after elections were recognized as a threat to this ideal, as they could destabilize governments and undermine the mandate given by the voters. Article 100 and the subsequent 10th schedule were introduced to address this concern directly. These provisions sought to create a framework where members of Parliament (MP) and members of Legislative Assemblies (MLA) would remain loyal to the political party under whose banner they were elected. This loyalty was not just about adherence to party ideology but also about respecting the democratic process and the voter's choice. The intent was to prevent a scenario where elected representatives could switch allegiances for personal gain or political opportunism, thereby betraying the trust placed in them by the electorate. Over the years, as the political landscape of India evolved, amendments were made to the anti-defection law to further clarify and strengthen its provisions. These amendments were aimed at addressing loopholes that allowed members to circumvent the original intent of the law. For example, the concept of deemed defection was introduced to tackle situations where a member might not formally leave their party but engage in actions that were tantamount to defection. These actions could include voting against the party's stated position, publicly criticizing the party leadership, or aligning themselves with rival political groups. The intent behind these amendments was to ensure that the spirit of the law was upheld, even if the letter was not explicitly violated. The exceptions to the disqualification rule, such as those related to mergers or splits within political parties, were also carefully considered to balance the need for stability with the recognition that political dynamics can change. The goal was to create a system that was fair and adaptable, allowing for genuine shifts in political alignment while preventing opportunistic defections. The interpretation of Article 100 by the courts has also played a significant role in shaping its application. The judiciary has consistently upheld the validity of the anti-defection law, recognizing its importance in maintaining political stability and preventing corruption. However, the courts have also emphasized the need to ensure that the law is applied fairly and that the rights of individual members are protected. This has led to a body of case law that provides guidance on the interpretation of the various provisions of Article 100 on the 10th schedule. The consequences of disqualification are intended to be a deterrent against defection. The loss of a seat in Parliament or the State Legislative Assembly and the subsequent ban from contesting elections for a period of 6 years are significant penalties that underscore the seriousness of the offence. These consequences are designed to ensure that members think carefully before considering switching parties and that they are held accountable for their actions. In summary, the intent behind Article 100 of the Indian Constitution and the anti-defection law is to create a system that promotes political stability, upholds the democratic process, and ensures that elected representatives remain loyal to the political parties under whose banner they were elected. The provisions of the law have been carefully crafted and refined over the years to address loopholes and adapt to the evolving political landscape of India. The interpretation of the law by the courts has also played a crucial role in shaping its application. The consequences of disqualification are intended to be a deterrent against defection. The framers wanted to make sure that if a party was going to merge with another, or if a significant faction broke away from the original party, the members' affiliations and loyalties may understandably shift. In such cases, disqualification would be inappropriate because the landscape changed and there was nothing the member could do. Therefore, the framers had the foresight to protect these members in this situation. The key provisions of Article 100 deal with various aspects relating to the functioning of Parliament and state legislatures. It outlines the rules concerning quorum in the House, the power of the Speaker or Chairman to maintain order, and the right of members to vote. Additionally, Article 100 addresses the circumstances under which a member can be disqualified from holding their seat. These provisions are intended to ensure the smooth functioning of legislative bodies and to uphold the integrity of the democratic process. The intention behind including these provisions in the Constitution was to establish a framework for the orderly conduct of legislative business and to prevent disruptions that could hinder the functioning of Parliament and state legislatures. By setting clear rules for quorum, order, and voting, the framers aimed to create an environment where debates could take place in a constructive manner and decisions could be made efficiently. Furthermore, the provisions relating to disqualification were included to maintain the integrity of the legislative bodies and to prevent individuals who have engaged in misconduct or violated the law from holding public office. Over time, as the political landscape of India has evolved, there have been various interpretations and amendments to Article 100. These changes have been aimed at addressing emerging challenges and strengthening the effectiveness of the provisions. For example, amendments have been made to clarify the grounds for disqualification and to streamline the procedures for determining whether a member has violated the law. These changes have been necessary to ensure that Article 100 remains relevant and effective in promoting the orderly functioning of Parliament and state legislatures. The consequences of violating Article 100 can be severe, including disqualification from holding public office and the loss of the right to participate in legislative proceedings. These consequences are intended to serve as a deterrent against misconduct and to ensure that members uphold the standards of integrity and accountability expected of them. In addition to the specific provisions outlined in Article 100, there are also a number of related laws and regulations that govern the functioning of Parliament and state legislatures. These laws and regulations address issues such as the conduct of elections, the privileges of members, and the procedures for enacting legislation. Together, these laws and regulations form a comprehensive framework for the governance of legislative bodies in India. In summary, the provisions of Article 100 are intended to ensure the orderly functioning of Parliament and state legislatures, to uphold the integrity of the democratic process, and to prevent disruptions that could hinder the functioning of these bodies. The intention behind including these provisions in the Constitution was to establish a framework for the orderly conduct of legislative business and to prevent individuals who have engaged in misconduct or violated the law from holding public office. The framers of the Indian Constitution envisioned a system of governance where elected representatives would be accountable to the people and would act in the best interests of the nation. Article 100, with its provisions on quorum, order, voting, and disqualification, was designed to contribute to this vision by promoting the smooth functioning of legislative bodies and upholding the integrity of the democratic process. The article has been amended over time to strengthen and clarify its original intent.